What assets can crisis Medicaid planning protect now? Imagine facing a sudden health crisis that requires immediate long-term care. You want to qualify for Medicaid quickly but also keep as much of your hard-earned assets as possible. That's where crisis Medicaid planning comes into play. It's a strategy designed for urgent situations, helping you protect certain assets while meeting Medicaid's strict rules. One of the main assets that can often be protected is your primary residence. If you or your spouse continue living there, the home is usually considered exempt. The value of the home that can be protected depends on your state, but generally, there is a limit on equity. For example, some states allow up to $250,000 in home equity to be protected. Personal belongings and household items like furniture, clothing, and personal effects are typically exempt from Medicaid asset calculations. These are items you need daily and are not counted against asset limits. If you own a vehicle used for transportation, usually one car is exempt. This applies whether it's used for commuting, errands, or medical appointments. The vehicle's value is not counted when determining Medicaid eligibility. Prepaid funeral and burial plans are often protected because they are considered non-countable assets. Paying for these in advance can help avoid spending down your estate later. Income-producing property, such as rental real estate, might be protected if the income is used properly. For instance, rental income can be used for care expenses or household needs, but rules vary by state. Legal tools like irrevocable trusts can also shield assets. These trusts are set up to hold assets outside your name, making them inaccessible for Medicaid purposes. Establishing such trusts requires careful planning and legal guidance to avoid penalties. Assets belonging to a community spouse, the spouse not needing care, are protected under federal law. This allows the community spouse to keep a portion of the couple's total assets, preventing them from becoming impoverished. The protected amount can be up to 50% of the combined assets, with a maximum of around $150,000. Retirement accounts like IRAs and 401ks may be protected depending on your state's rules. If you are taking distributions, those funds might be counted as income, but the accounts themselves often remain protected. It's important to remember that Medicaid has a 5-year look-back period. Any transfers or gifts made within that time frame can trigger penalties, making asset protection more challenging. However, legal strategies and careful planning can still help preserve significant assets. Working with an elder law attorney is essential. They can help identify which assets are countable or exempt, establish trusts, and develop a plan to protect your assets quickly and legally. They can also help you understand income limits and set up arrangements like a qualified income trust if needed. In summary, crisis Medicaid planning can protect your primary residence, personal belongings, one vehicle, prepaid funeral plans, certain trusts, and protected assets of a community spouse. It's a time-sensitive process that requires expert guidance to maximize your asset protection while ensuring you meet Medicaid's eligibility rules.